It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my wholesome co-host, Brett.
Oh, wholesome. Alice, I'm so touched. I like to think of myself as wholesome. I'm like Beaver or something.
Okay, don't let it go to your head because you're not wholesome at all. But sometimes the truth has to take a back seat for my puns to work to go along with our Legal Briefs themes.
I see. I see what's important here. I see what's
all
important.
of you guys are like with, double fist and bourbons. That guy ain't wholesome. We all heard your bar exam story. Please.
Killing me, Alice.
Oh, but I still love you. If you were too wholesome, this would not be as fun of a podcast because, I'm like as boring as it gets.
Stories. Love your stories. Oh, whatever, Alice. Just listen to more of your stories of all your adventures you've been on.
Adventures, but I'm always wholesome.
Yeah, I can't make that claim.
Well, for those of you who don't know what I'm tying this to, today we're going to talk you guys through the entire life of a case, the whole case progression, because a lot of you guys have asked, and these are great questions, because oftentimes in the news, you'll hear like snippets of parts of the case progression, and it's not exactly clear where they fall within the actual life of the case. And if you have like a framework to understand how a case progresses, you're going to be like 95% more educated, I think, than most people reading the articles about some headline in whatever case you're following.
Yeah, and it's so easy to forget for us that you guys don't live this. Even if you're really big fans of true crime, these are the kind of things that they're really mystery. And we've seen this a lot with the Delphi case and with the Idaho murders case. People are following that just hit to hit. And right now, we're in so much preliminary stuff, and people are really confused about things, and they want to know like what's going on, and what does this mean, and what does that mean? And so we thought, hey, let's just walk through a case and just lay it out, and the way it goes, step by step by step, so you guys will have an idea. And hopefully, when you finish this, like Alice said, you'll be able to understand this, and going forward, when you hear these terms and you see the way things are shaking out, you'll have a feeling for what it means, and if it's significant or if it's that's just what happens. And look, the very beginning of any case is the investigation. Everybody's seen Law and Order, and you have the police who investigate the offenses and the prosecutors who prosecute them, and together they're Law and Order, whatever. And that is really true. That's the way it works, and it works that way with every single crime you could have. We can't do our jobs without our agencies, without our police officers, without our agents, and they can't do their jobs without us, and we really are working in tandem. So you start off with an investigation, and this can be anything from the most innocuous shoplifting case to a capital homicide. You have a crime that's committed, or the suspicion of a crime that's committed. Some crimes are obvious. Murder's obvious. Somebody's dead. Somebody's been murdered. Other things like frauds, that kind of thing, complicated financial stuff. Sometimes there's a question of whether there even is a crime, whether the money being moved in the way it was fraudulent in the first place or legitimate. But either way, you have a suggestion, a notion that some law has been broken. And your agents are going to work on that. Your police officers are going to work on that. And the extent to which the prosecutors are involved at that point can really run the gamut. It can be the prosecution is in it from day one, on the ground, working with the officers to figure out how to proceed with the investigation, what subpoenas are needed, who needs to be talked to, what leads need to be followed, to the police are really doing their own investigation. And it's only brought to the prosecutor once it's kind of wrapped up in a bow and it's ready to move forward. And Alice and I, we've seen both sides of that. I mean, we've been in investigations, years-long investigations, and that's the most fun when you are in it with your guys, working it, figuring it out, seeing the twists and turns. But we've also seen it where somebody shows up with a file, plops it on our desk, and is like, "Here you go, prosecutor. It's all wrapped up and ready to go."
Yeah, absolutely. So, I mean, this is just so wide-ranging. But the important thing to know is this is the part that the public typically does not see, except for really high-profile murders like the Idaho murders or the Delphi case, where the investigation is kind of scrutinized because everyone knows about the crime, the murders in those cases. The public knows about it. But typically in a case, no one knows in the public that an investigation is going on because it's fact gathering. There's obviously not a showing of probable cause yet to be able to bring a charging document. And so because of that, that's why you have so many things, under wraps. When you talk to witnesses, you have to decide what order to talk to witnesses because people can start talking, word can get out that law enforcement's looking into XYZ conspiracy or something like that. And like Brett said, I can't emphasize this enough. People don't realize that investigations typically take much longer than you think. It takes longer to gather evidence, especially when you don't know exactly where you're starting. Subpoenas take time to come back. People don't turn over documents the next day once you issue a subpoena. You have to actually go, to the grand jury to ask for a subpoena. It's issued and then it has to be served. And sometimes it's hard to serve an entity. You may not know where they are. Maybe they're on the run or they're a big entity. They're like, Google, and there has to be the right service processor that gets the subpoena to be able to process your subpoena. And then there's typically some amount of time before the documents come back. 30 days, sometimes longer if it's a large amount of information. And then once it comes back, your agents have to be able to process that information, draw, connections between things, have additional leads to what to do next. So the investigative process is fascinating. It is awesome. And because it's not in the public eye, you guys don't see how much experience needs to go into it. I mean, a lot of it is by past experience, to know where to look next, to draw the connections that nobody else sees. I mean, it is the ultimate puzzle that you're putting together with absolutely no roadmap. I mean, it's fascinating. So people who want to be agents, this is an awesome path to be on. Neither Brett or I are agents, but having worked side by side with agents, I can see how it is such an exciting career path, especially if you like to solve mysteries, really, to solve puzzles and to kind of be the one in control, to be the one to overturn maybe that key piece of evidence that can crack the case wide open. And that's all happening on the investigative side. And like Brett said, sometimes the prosecutors are involved. I agree. I love those types of cases. You get to know people really well when you are spending, hours in the car together, chasing down leads or interviewing witnesses or pouring through seemingly boring documents to try and find, the golden nugget within the financial records, because you guys may think it's boring, but all those bank records, they really reveal a lot about, whether someone's hired a hitman, for example.
And it's interesting because it's just funny watching sort of the Idaho case unfold in real time and people examining every single thing that's happened in the case and trying to figure out what it means. Some of this is you're just firing off subpoenas because you think there might be some evidence there, and there are a lot of dead ends. So just because you see a subpoena go out and you're just looking at a docket and you see subpoena to this thing and you're like, oh my goodness, what does that mean? What are they looking for? They might have just thought, there might be something there. Let's check and see, because there are so many dead ends that you run into during an investigation. But a good investigation chases those leads down.
Absolutely. And sometimes it isn't just, it's also to make sure there is nothing there. So you may think likely this entity will know nothing, but you don't want to be surprised later on if that is absolutely something you should have checked into. You did not. And it ends up being the exonerating evidence, for example, or something that makes your case a lot more difficult. And you have to be ready for that. So that's why you are very, very broad in your investigative state. And also that's why it's really all under wraps, so that just because someone gets a subpoena doesn't mean there's been any wrongdoing by that entity or to whoever they serve. And then once you get the investigation wrapped up, and here is where the experience matters, because an investigation could potentially never be over, right? So at some point you have to decide to move forward or cut the case loose. And that has to do with both the agent and the prosecutor kind of putting their heads together at this point of the case when you're trying to decide whether to move forward or keep investigating. The prosecutor does weigh in because they're kind of applying the facts that they have to the legal standard at trial. So not just for the probable cause to bring a charging document, but to see if they can win at trial and to run down all those leads and to make sure that there's no stone unturned that could make you look really bad as the investigator or as the prosecution if you didn't run it down. But once you've reached the point where you believe you have enough to get a conviction at trial, you move towards a charging document. And that can be either a complaint or an indictment by grand jury. So the indictment by grand jury, we've talked about a good bit, but a grand jury, everything that happens in a grand jury is secret. It is not adversarial. Only the prosecutor goes in. There is a court reporter who takes down everything that's being said, but the prosecution goes in and puts on witnesses, including, say, the case agent, to establish probable cause that a crime has been convicted, and the grand jury of your peers votes on whether to issue a true bill, which means they have issued, you're allowed to go forward with an indictment. And if they return a true bill, then you do have an indictment, and then we'll go on from there. But that's how the grand jury process works. And again, because the defense is not represented in the grand jury, the prosecution has to present any exculpatory evidence that they have as well. And so while it's secret for the time being, when the case progresses and any of those agents or witnesses will testify, we then have to turn over the transcripts from grand jury. So it's secret up until a point.
Right. And if you don't go by indictment, and we talked about this a lot in some of these state cases in particular, but it can happen in federal court too, where essentially you can charge someone and arrest someone on the basis of a complaint. And a complaint is just an affidavit sworn by an officer who basically says, look, I have all this knowledge. There was a crime committed. Here's all the reasons to think it's this guy. We need to arrest this guy. And that's sufficient to get an arrest warrant and arrest somebody. But it's not enough to move forward to trial. At some point, you're going to have some sort of ultimate finding by an independent arbiter, not just the cop who wants to arrest the guy, that there's actually probable cause. If you do indictment by grand jury, obviously the grand jury is finding that, and that is sufficient. But the indictment by grand jury can happen after a complaint. So you arrest the guy, maybe you don't have time to go to grand jury. Maybe you need to get this guy arrested right now. Maybe you're never going to go to grand jury, and we'll talk about that in a second. But you can have these complaints where someone's arrested. You can have an indictment issued by a grand jury, which then results in an arrest warrant, and then the person's arrested. Or you can have a complaint that's then followed by an indictment by grand jury. But these are the initial sort of the documents, the actions by the prosecution in the state that result in someone being arrested for a crime. And after they are arrested, they have certain rights. And one of those rights is to appear in front of a magistrate and to be told why they were arrested. This is often called an initial appearance. In your initial appearance, you are told why you've been arrested, what the crime is, what the elements are, and you are given the opportunity to either hire a lawyer or to have a lawyer appointed to you. So you're sort of told your basic rights by the judge, told why you're being held, and given an attorney. This is not when you plead guilty or not guilty. That is an arraignment. These things are often conflated, but the arraignment is when you're once again read your rights and told the charges against you, but you also, at that point, are expected to plead one way or the other guilty or not guilty.
That's right. And there's like a very short amount of time in which you are arrested that you have to have your initial appearance to maintain your constitutional rights. But one thing about the complaint and the indictment, they are under seal until you are arrested, because for obvious reasons, if you know that you're going to be arrested, you might do something like flee. And so while there's no like constitutional number of days that can pass between when you are issued a complaint or an indictment to be arrested, the time does start ticking once you are arrested to be able to be seen by a judge or a magistrate to be read your rights. But do know that if you delay, if the prosecution delays too long to arrest you, you run into troubles, and there's ways to attack that. But some of you may be wondering, well, when do you go complaint? When do you go indictment? Sometimes it could just be whatever's available at the time. So a big reason to go by complaint is it can happen at any time, because the magistrate judge or the judge is always there sitting, available to hear an emergency situation, whereas the grand jury meets at certain set times throughout the month, and they may not be sitting to hear a particular case for indictment, and maybe your guy's about to run. I had a situation where it wasn't a violent crime, because you can imagine if it were a murder or something, you can imagine why you'd go by complaint, because you need to get the guy right away so there's no harm or no danger to the public. But I had a situation where it was not a violent crime at all. It was a very serious crime. It was a felony, but we had reason to believe that this guy had a plane ticket and was going to flee the country within the next 48 hours. And so even though he wasn't a violent offender, we had very real reason to believe that we would not be able to find him again if he left the country, because of the way that he had kind of structured his travel plans. And we understood that he knew we were onto him. So we moved quickly with a complaint, but then quickly followed with an indictment right after that, because we had him secure and we took away his passport and knew that he wouldn't flee. And just so you know, we were right. He was absolutely going to flee to like the middle of nowhere, and it would have been incredibly difficult to bring him back if we had allowed those 48 hours to pass.
And speaking of fleeing, that's another thing that happens at this initial appearance is a determination is made about whether or not the person is going to be released or not. And that's a complicated thing. You can end up having a hearing about it, a bond hearing. It depends on whether you're in a state or the federal system. It depends on whether you're in a cash bond system where, you might have a $500,000 bond that you have to meet, or whether it is a system that decides whether or not you'll be released based on the danger of flight or the danger to the community, in which case we're not going to say it's some amount of money. It's just you either are a flight risk or you are a danger. And if you are, you're going to have to stay in jail until the trial. Or you may get a bond. And bail and bond, it's always confusing to people. Bail is basically, we are going to release you. The bond is the document that you have. It's kind of like a mortgage. It's like your freedom mortgage that says, you get to go out. And if you violate that bond, then you're going to go back and you're going to have to wait until the trial to get out. But that's another thing that happens around that initial appearance time. And like Alice said, that can be an important reason for why you're doing a complaint in the first place, because you need to get that person off the street, or you think they're about to get on a plane and fly away for forever. Another thing that happens right during this period is discovery starts. Once you're arrested, once you have an attorney, the discovery process begins. And it's a long process, and it's an ongoing process. And you're having initial discovery where you're turning over the initial evidence you have, but different pieces of evidence. Number one, obviously things that you discover as your investigation continues, even post-arrest, you're going to continue to provide. There are certain things that aren't triggered until later on. An example of this, there's something called jinx material. If someone is going to testify, then their prior statements have to be turned over to the defense. But because they only have to be turned over if they testify, they're actually not required until the person actually testifies. So you can have a statement that you don't have to give the defense until that person gets up on the stand and testifies. And then the defense has the option of requesting any statements that they made previously, at which point you have to turn them over. Now, a smart prosecutor will probably make a deal with the defense to give those ahead of time, because you don't want to delay the trial. You don't want the defense to be like, well, Your Honor, I need time to review these statements. And so you might do that earlier. And that's where discovery can really be the kind of thing where you're working with the other side, where even though you're against each other, you're working together to make this as smooth a process as possible so everybody gets what they need so that we can go ahead, have this trial, and have a determination about guilt or innocence.
And you can understand why discovery begins really at the initial appearance arraignment at the very beginning, because up until this point, the investigation has all been on the prosecution side. But the defense now wants to start investigating their side of the case to see what the prosecution has, how to rebut it, to go talk to these same witnesses, to see if they really are going to say what the prosecution's file says, to see if there's any alibi, all these sorts of things. And so in order for them to do that, they have to be able to know what the prosecution has, because they're in some ways starting later in their investigation than the prosecution was. So they in some ways get to start ahead of the start line because of the way this entire case is structured. Now, we've talked about a preliminary hearing. So then a bunch of things can happen. They don't have to happen, but once arraignment has happened, usually a case is relatively quiet. But there are certain things that can happen that the defense can bring in order to start challenging the prosecution's case before it even moves towards trial. And one of those is a motion to suppress. And motion to suppress, to finish that phrase, is to motion to suppress evidence. So you've probably heard of this, like violations of the Fourth Amendment, for example. If there are violations of your constitutional rights, then the defense can argue that that evidence, even if the prosecution now has it, would never be allowed in. You can't use that evidence to prove the guilt of your defendant because their constitutional protections have kicked in and they would never have been, for example, searched in a traffic stop. So if that's a very common kind of basis for a motion to suppress, if there's a traffic stop, and by the way, there's almost always a valid reason for a traffic stop. You probably didn't use your blinker. You probably were going above the speed limit. Maybe you tailed someone too closely, something like that. But once you stop someone, you don't just get to frisk them. You don't just get to search their car. Something has to trigger that ability for kind of those constitutional protections to go away and for the law enforcement officer to be able to search. So let's say that there was absolutely no basis for them to search your car, but the officer just doesn't like the way you look. And so he pulls you out of the car and you're like, hey man, don't search my car. And the police officer insists on searching the car and finds a bag of weed. And weed is illegal in your jurisdiction. In that instance, you can imagine that a motion to suppress the actual evidence of the weed may be brought by the defense, should be brought by the defense, because they'll challenge that the defendant's constitutional rights were violated because the police officer had absolutely no right to search the car. And it does not matter that his search proved fruitful. And there are other dispositive motions that can be brought during this time to attack the indictment kind of from a factual basis, from a legal basis, before you even move towards whether your guy did it or not.
And you can see how these motions get rid of the whole case often. Not always, but often, the example Alice gave, if the weed's suppressed, guess what? You don't have a case because now the evidence of the crime is gone. Other times, there can be motions that suppress some important evidence, but you still have other evidence so you can move forward. And then there are things like motions to dismiss the indictment, maybe a double jeopardy claim, something like that. These are sort of the big motions, and you deal with these kind of early on because you want to get these out of the way so you can start moving towards trial. Before you get to trial, though, usually there's a plea deadline. And the idea is before the court starts getting a bunch of people together for jury duty and figuring out everything and ruling on a bunch of motions, we're going to set a deadline and say, hey guys, if y'all are going to plea, do it by this date. This is a soft deadline. At the end of the day, the defendant can plead at any time. It's his right. But, if you want to enter into some sort of plea agreement that has a bunch of stuff the court's going to do, courts actually have the option in certain circumstances to reject plea agreements. They can never stop a defendant from pleading guilty, but they can reject certain kinds of plea agreements. So the deadline can be helpful in sort of organizing things and getting everybody in place. It also helps defense attorneys because they can go there to defend and say, hey man, if we're going to do this, we're either going to trial or we're not. Here's the date. And those dates can be very powerful. The number of times where a defendant says, like, I was supposed to have a trial in a couple weeks. And wouldn't you know it, the Friday before the Monday plea agreement, all of a sudden I'm getting a call about he's had a change of heart. This is the same type of thing, right? That's going to happen. So you have that. And then once that sort of gets out of the way, now you're really thinking about trial. And you start having motions in limine. And motions in limine are all about limiting what is going to happen at trial. So I'll give you an example. Motion to suppress. Defense moves to suppress the gun because it was planted by the police officer. We have a hearing, and the judge says, no, wasn't planted, denied. Well, I might file a motion in limine that says, hey, I want to prevent the defense attorney from bringing that up. I do not want the defense attorney to be able to argue to the jury that this gun was planted because we've already decided that. That has been decided. That was a question for the court. The court has decided that question. They should not be able to relitigate that to the jury. In a case like that where it's kind of facts-based, I might win that, I might not win it. In another circumstance where, say, it was a pure question of law, like whether the dog that sniffed the marijuana, whether he, abided by the legal requirements thereof. That's a pure legal question. It's not a factual question. Very likely that the court's going to say, look, I decided that dog was legal. You can't argue to the fact finder, which is the jury, these legal questions. So you can't argue that. So that might be a motion in limine. I would file another thing, 404B evidence. We've talked about a lot. Defense might say, hey, we want to keep the prosecution from bringing up the fact that our client who's being charged with robbery has been convicted of 10 prior robberies. We want to keep that out because it's very prejudicial. And then we would argue, no, that's exactly the kind of 404B evidence that should come in. And you argue all that in these motions in limine so that you're not arguing it in the middle of trial. You're not holding up trial with objections and with long sort of winded arguments. The fact of the matter is, most legal stuff is not done on the fly. It's not somebody standing up and just brilliantly quoting cases and arguing to the judge about why this piece of evidence should go in. The vast majority of that is and should be done before you even walk through the door. That all should be handled. It should all be dealt with. So those big legal questions and complex legal questions have already been decided.
Absolutely. And just so you know, when you see these dockets, most trials will have many motions in limine filed because you kind of limit each of these motions in limine to the specific ask of the court. So they could be as short as, 4 pages, maybe no more than really 10 pages, but you usually don't combine all your different asks within one motion because you want separate rulings. You want the answers to be very clear on each of your issues. And so when you see like a flurry of motions in limine before trial, that's very, very typical. And then once you get those rulings, and the court will rule on many of them, but they may hold judgment in abeyance on some of them. And that's where you have some sidebar arguments. So there may be a full oral argument on a motion in limine, but the court may say, let's see if the defense opens the door for the 404B evidence. I'm going to hold my judgment until the trial gets moving. So there may be some that are still kind of open in limbo at the time, but then you move towards trial. Let's say everyone's moving straight towards trial. What happens first? If you guys have, watched any sort of TV, you know that it's jury selection, and that goes with voir dire. So people are summoned to be part of the panel, and it's going to be a lot more people than are ultimately picked. But jury selection is different in every single jurisdiction. Sometimes it's the judge asking all the questions. Sometimes the defense attorney, the prosecution ask the attorneys. But whatever it is, what they're trying to do is not pick the jury per se, but it's kind of the opposite. They're trying to weed out people who are clearly biased and should not serve on a jury. And so that's kind of, instead of picking your jurors, you're really picking out jurors you don't want on your jury. And so that's why questions of, can you be unbiased? Have you heard of this case? Do you have any personal relationships with any of the witnesses in this case? Do you know anyone else in this room who may be serving on the jury? Those sorts of things. It's getting at really your ability to be a neutral arbiter. And once that process has taken place, and those of you who have been called for jury duty, it takes a long time. It usually takes all day. The jury is called. And for a criminal case, you'll have 12 jurors and usually some number of alternates. And the alternates are there in case life happens, someone gets kicked off the jury because of something they've done or just because of life. They get sick. A child gets sick and they have to be called away. And then that way there's not a mistrial and the sitting jury has still heard all the same evidence and an alternate can fill that spot and, step in for the juror that had to step away.
Yeah. And one thing I want to point out about some of the stuff we talked about, as you're following these developing cases, there's going to be a lot of stuff filed, a lot of motions in limine, motions to suppress, motions to strike, motions for discovery, all this other stuff. And people are going to freak out and lose their minds. This is all standard trial practice. That's one reason we're going through this. This is all standard stuff, and you're asking for things that you're probably not going to get, but you feel like it's your job to do it. You're hoping maybe you can win one here or there. Just because somebody files something doesn't mean that it has any merit whatsoever. So just remember that when you're seeing stuff get filed in these cases. So once a jury is selected, then we're going to start trial. We're going to have our opening statements by the prosecution and the defense. These statements are not meant to be argumentative. Sometimes, even we will mess up and call them opening arguments, but they're not. They're opening statements. They're not supposed to be arguments. You're supposed to be just stating sort of the case as you see it, the evidence that's going to be presented, what you expect the jury to learn, giving the jury a roadmap for the case, what it's about, because unless it's a famous case, the jury probably has very little knowledge. Even at that point, during jury selection, you might tell them, hey, this is a fraud case. And you might ask them, do you know this person, and that person? But other than that, they're not going to know anything. So this is your first opportunity to lay out for them, hey, it's a fraud case. These people, they stole a bunch of money from a bank. Here's how they did it. You're going to hear from this guy, and he's going to talk about this thing. You're going to hear from this guy, and he's going to say this thing. And we're going to show you some charts. And then the defense gets up and says, the burden's on the prosecution, and they're going to try and show you this, but they're not going to be able to, because what you're going to find out is they can't explain X. And there's this other guy that was doing this thing, and my client, he was just doing his job, right? Sort of laying out how you expect the evidence to come out. And then it's on the prosecution. Prosecution goes first. The burden is on the prosecution. The prosecution has to meet that burden. By the time the prosecution rests, the prosecution needs to have met the burden of put on enough evidence that a reasonable jury could find beyond a reasonable doubt that the person is guilty. Doesn't necessarily mean that the jury will find that. It's just, did you put on enough evidence to meet each element of the crime? Did you just show that it happened in this district? Did you put on evidence that there was a fraud and that money was stolen and that maybe this person had knowledge? If you missed any of that stuff, say it's a federal case and you have to prove that this stuff was happening in interstate commerce, which is something you have to do in a federal case because you only have federal jurisdiction if there's interstate commerce. And say you prove beyond any doubt that there was a robbery and every other element, but you forgot that. You never showed there's interstate commerce. Well, you rest, and at that point, the defense stands up, and they do this in every case, whether they have a real argument or not, and makes a motion for judgment of acquittal. In the case I just described, where you forgot the element and you didn't put on any evidence of interstate commerce, the judge might well grant that, and probably should grant that, and say, sorry, prosecution, you did not show that the business that got robbed was operating in interstate commerce. And since you didn't show that, you did not prove a necessary element, and therefore the jury can't find this person guilty because there's no evidence on this element. Therefore, judgment of acquittal, case is over, and it just ends there.
And by the way, that's why a lot of you who are watching the Murdaugh trial thought like, oh my goodness, this is so boring. They have, records custodians getting up there and saying, is this how Snapchat works? That's why they have to do all of this, because the burden is on the prosecution. And if they fail to meet any of those, even what you may think is a boring element, you lose. You absolutely lose. And so the defense doesn't have to do that. They just have to poke holes and tell a story, but they don't have to prove all the elements of the case. So that's why the prosecution phase of the case may feel a little bit more like drudgery, because there's a lot of boxes that have to be checked under the law. Otherwise, the judge will grant the motion for judgment of acquittal, which, like Brett said, is always moved for. Like, if you don't move for it as the defense after the prosecution rests, that's probably a basis for ineffective assistance of counsel. So when you see that happen, don't freak out. You should freak out if it doesn't happen because something weird has happened. So that always, always happens once the prosecution rests. Now, there's usually argument. The jury does not hear the argument, and there is a ruling made at the time. Almost always. Sometimes the judge will say, I'm going to reserve judgment, but let the rest of the trial proceed. So if the case is not kicked at that point, then it's the defense's case. And the defense gets up and now gets to call whoever they want. They can call back any one of the witnesses that previously took the stand. So something I've seen a lot of people ask is cross-examination which when it's at the prosecution's phase of the case, the defense is doing all the cross-examination. Cross-examination is limited to what was brought up on direct examination. And some of you have asked, well, doesn't that mean the prosecution can just keep out entire swaths of information from being brought out just by not bringing up indirect so that the cross-examination can never touch upon it? Kind of, yes. However, the defense can always call back that same witness and now direct them. By directing them, they have to actually not lead the witness, and you have to approach the witness in a different manner than if you cross-examine them. But don't be under the impression that just because cross-examination is limited to what happens in direct, that somehow keeps out certain information. The defense may choose not to bring back that witness because that witness is really bad for them, but that's like a judgment call for them. All to say is the defense puts on a case or not. The defense is not required to put on a case at all. So in most cases, actually, probably not the hot button cases that you see on the news, but most cases that we prosecute, the defense never puts on a case at all. After the motion for judgment of acquittal, if it is not granted, if it's denied, they rest. There's always talk about whether the defendant will take the stand or something like that. Or they might put up one or two kind of character witnesses. Maybe the person's mom. He's such a sweet boy. He would never hurt anybody. Or his best friend who knows nothing about the crime and just can talk about what an upstanding citizen and father or, mother this defendant is, to kind of draw sympathy from the jury. But it could be very short, if anything at all. And then the defense will rest. So that phase of the case will almost always be shorter than the prosecution phase because the prosecution has already laid out all the evidence and there's been a chance to attack that evidence through cross-examination. And so those of you who say, oh, why didn't this particular defendant put on a case? They kind of have through the cross-examination. So just because you choose to rest without putting up a case doesn't mean you've done nothing as the defense. This is all strategy and tactical judgment.
And let me just say, I think probably the majority of cases, maybe even the vast majority of cases, the defense puts on no witnesses. That is not unusual. People think that's weird. Sometimes you'll even see in sort of innocence type podcasts that are challenging a conviction, they may even criticize the defense. They didn't even put on any witnesses. That's pretty common. It's pretty common because one of your strengths as a defense is to say, look, it was their burden. And you can almost use that. We don't even need to put on witnesses. They didn't prove anything. Why should we put on anybody? It's not our burden, right? And you'll see that a lot from defense attorneys, particularly when they don't have a very good case. They'll use that because it's kind of the only thing they have. But you'll see that sometimes. Now, we always say defense doesn't have to say anything. There are exceptions to that. There are things called affirmative defenses where you are saying, look, take self-defense. Self-defense is an affirmative defense. So basically, with self-defense, you're saying, yeah, I shot the guy. I admit that. But it was self-defense. Now the burden's on you to put forward some evidence of that, to show that it was self-defense. And the prosecution may have to rebut that. Well, in that case, you do have a burden to put on some evidence. Insanity is another one. You may have to show that you're insane. And in those cases, you are expected to put on some sort of evidence. Now, you may have a renewed motion for judgment of acquittal at the conclusion of the defense's case if there are things that sort of are part of the defense's case that at that point you can ask the judge to reconsider his decision at the end of the prosecution's case. A lot of times this will actually happen after a verdict because really, once again, the defense's case is not so much about proving or disproving things unless you have this affirmative defense as it is casting doubt in the mind of the jury. And that's not really a basis for a judgment of acquittal. But you might see this if you have an affirmative defense. But usually, you're kind of, at that point, defense, they end their case. The prosecution can put on rebuttal if they want to. Sometimes that happens. You saw that in the Murdaugh trial, for instance. There was some rebuttal evidence. Most times there's not. Most times there's no rebuttal from the prosecution. And obviously, the prosecution can only put on rebuttal if the defense puts on a case. If the defense stands up and says, we got nothing, Your Honor, the prosecution can't be like, oh, well, we got some more guys we wanted to call. No. Your rebuttal means they said something, now we're going to rebut it. And you're limited to that. You really need to be able to show how the witness you're putting on is rebutting something the defense said. If you don't have that, you move to closings. The prosecution has the burden, so they go first and last. They get 2 bites at the apple. And this is when you're doing an argument. Now you're using all the evidence that's come in. You're making an argument to the jury. You're arguing why they should find someone guilty. It's really the first time that the prosecution gets to say, this is why they're guilty. This is why you should find them guilty. And that's why the arguments sound different in tenor than the opening. So you're going to make that argument. The defense, they're going to make their argument for why the prosecution didn't meet its burden, why they failed to prove that the person is guilty beyond a reasonable doubt, where that reasonable doubt is, showing that doubt, creating that doubt for the jury. And then the prosecution gets the last word in which they say, hey, here's all the reasons you should ignore what the defense just said. We actually did prove our case. Find this person guilty. And one thing you're always going to say in your closing argument is the judge is going to instruct you on X, Y, and Z. And we said this many times, the jury finds facts. The judge finds the law. And so what the judge does after closings is there'll be jury instructions. The parties will have come together with the judge. They will have reached some agreement on jury instructions. The defense or the prosecution may have objections that sort of stand. The judge makes a final call about how he's going to instruct the jury. And instructions are things like, here, he's been charged with wire fraud. Here are the elements for wire fraud. And lay them out for the jury. This is what you got to find, that this person used the wires to make a material misstatement to someone for the purpose of defrauding them. And they did it in interstate commerce, and they did it here in this jurisdiction. And you might get an instruction on what reasonable doubt is. Like, hey, you're probably wondering, what's reasonable doubt? Well, here it is, and give you an instruction. And all these instructions can be different things depending on the facts of the case. I mean, imagine if you have someone who fled the jurisdiction, there may be a flight instruction where you say, the jury, you can find that flight is an indicator of guilt. So those would be the kind of instructions you have. And the whole idea is the judge is trying to structure what's going to happen next, which is the jury deliberation.
Jury instructions are pretty formulaic. There's usually in each jurisdiction like a book of templates of types of instructions, and you'll kind of not fight, but you'll debate on what is proper for your particular case, but you're not kind of writing them out of nowhere. They're kind of the same types of jury instructions, but whether that particular situation matches onto your case. So once the jury instruction, and they are long, usually the jury instructions are very lengthy. I always feel like it's such a downer after like the exciting closings, and then you sit through kind of like an hour of instructions of what to do. But that's what happens. And once that happens, then the case is turned over to the jury, and they are excused to go to the deliberation room, and that's where they deliberate. And that's the black box of the jury. The attorneys usually have to stick close around to the courtroom so that if there's a verdict, they can come back, to hear the verdict. So all the evidence gets sent back with the jury. They can look at it, but no one can explain to them or tell them what it is. So if they have a question about something, they can write the question and give it to usually the court officer, who will hand it to the judge. And the judge will typically read it to the attorneys and ask, how do you want me to respond to this? Sometimes the judge will say, I can't answer that question. Rely on your memory, whatever it is, especially if it's a factual question, like, hey, what did that witness say? Almost always the response will be, you're just going to have to rely on your memory, all of your memories. And once they deliberate, if they come back and say, we really can't reach any sort of a verdict, they may be given something called an Allen charge, or basically just to say, like, try harder, try to get to a unanimous verdict. And if they do come back with a verdict, then we have a verdict. Everyone files back. The jury files back and sits down. The attorneys are called back. The defendant, their family members, whoever's, the public who wants to see the verdict, all file back in. And this usually happens close in time to when the jury indicates that they have a verdict. And then the verdict is read. And the verdict is a literal form, a verdict form, that the foreman, who is kind of the lead of the jury group, fills out. And they will literally check a box that says guilty or not guilty for all of the charges that are brought, and if there are special circumstances that have to be found. And that verdict is read in open court by the judge. And the defense has the option of polling the jury. We saw this in the Murdaugh trial, where the defense says, I'd like the jury to be polled. And that's All that means is that each juror is asked if that is their vote. Juror number 1, 2, they go down the line, and I've never seen it be anything other than every single one of the jurors say, yes, it was, or yes, it is. That's my vote. Just to make sure that no one misunderstood what they were signing up for in that vote. And once the verdict is read, if it is a guilty finding, and if it's a mandatory remand, meaning that under the law, the defendant has to be brought under custody, they may directly be led from the counsel table straight back to the holding cell. And people are always surprised when something like that happens because it's very immediate. You don't have time to gather your things. You don't have time to say goodbye to anyone. It's at that moment you are no longer innocent until proven guilty. You are proven guilty. And so under the eyes of the law, you are convicted. And therefore, if you have mandatory remand and have to be held in custody, there is no delay in that process. There are situations where there's not mandatory remand and that person would not have to be handcuffed and led away. That happens in a lot of white collar cases, for example, where there's not mandatory remand. They get to go about their lives until the sentencing. And the sentencing typically happens at some time after the verdict. And Brett, in my experience, it's usually actually months because a lot of work goes into the sentencing, but some jurisdictions move directly into sentencing, like within the same breath. And so that can happen as well, but sentencing does follow the verdict. And the sentencing is done by the judge, not the jury. So the judge is usually presented with some sort of argument from both sides as to what the sentence should be. Usually the probation officer has done some sort of report that gathers information about information that would be relevant to sentencing. Maybe the person's health, their financial situation, if there's any dependents who depend on them for care, those sorts of things will be brought up during sentencing, but no longer are you arguing about whether the person did it or not. It's about mitigating factors if you're the defense, and it's about the, sentencing guidelines or what the statute provides for that particular charge.
And so once the judge has handed down the sentence, then you get into the appeal world. And the way appeals work, and I'll just go through these quickly. We can talk more about appeals later, and it's confusing, so we'll just lay it out. You have an appeal. Let's imagine it's a state case. So you're convicted in state court. Say it's murder. You're convicted of murder in state court. You can appeal to the Court of Criminal Appeals, and you can argue all sorts of things. You can argue, for instance, that there wasn't enough evidence, that the court should have granted your motion for acquittal, that they didn't prove that it happened in interstate commerce or whatever. You can argue all that stuff, and it's a much more sort of substantive appeal. You're really arguing about your guilt or innocence and whether or not the state met its burden. So then let's say you lose there, then you can appeal to the state Supreme Court. At that point, you're making the same arguments. Let's say the state Supreme Court denies you. You were able at that point to appeal to the United States Supreme Court. You go directly to the United States Supreme Court. You cannot appeal a state decision to a federal district court or a federal court of criminal appeals. Those courts do not have jurisdiction over states. The only court that has jurisdiction over a state Supreme Court in these cases is the United States Supreme Court. So you lose your appeal in state Supreme Court, then you appeal to the United States Supreme Court. Let's say they deny it. So now your appeals are exhausted. Your direct appeals are exhausted. Now you go to something that's called post-conviction review. Post-conviction review is usually more about constitutional issues. So things like my lawyer was ineffective, had ineffective assistance of counsel, or prosecutorial misconduct. There was a bunch of Brady violations. They withheld a bunch of evidence. The way that works is it starts in state court once again. You have something, it's different things depending on the state. Like one state I'm familiar with, it's a Rule 32 petition. And that actually starts in the trial court, where you were tried, with the trial judge hears that. The reason for that is he's very familiar with your case, and so he has an advantage. So you sort of make all your arguments to him about how your lawyer was ineffective. And maybe, he presided over the trial. He might be like, yep, he sure was. and you might, win at that point. Assume, however, you lose. You then appeal once again to the Court of Criminal Appeals. You then appeal to the state Supreme Court. Well, now, once you finish there, you don't go to the United States Supreme Court. Then you file something called a 2254 in state court. And what that says is that actually starts in district court, federal district court. And you say in federal district court, My United States constitutional rights were violated. I tried to get the state court to realize how awful this was. They denied me. Here's the final decision of the state courts denying me. You should find that they're unreasonable. And the federal court is supposed to defer to the state court, so it has to be really wrong, basically. Got to be really wrong for the federal court to grant you relief in this case. But you can make that argument to district court. They deny you. Once again, you go to the appeals court. Then you go to the United States Supreme Court. Once that appeal is complete, technically at that point, your appeals are finished. You don't have any more appeals. And the only way you can get back into court is with something like newly discovered evidence, a change in the law. So say the Supreme Court changes the way the law works, you might be able to file another habeas petition, something like that, a Brady violation, something like that. You really need something new in order to get back into court. And you'll see that in some of these cases that are really old and are being litigated, and you may wonder, like, why can't they just do something? And the reason is there's no vehicle for it, because unless you can show something new has popped up since you exhausted all your appeals, you can't just go back to court and argue it again. You need something new. Once you've argued it and the court has ruled on it, you're done with that. Now you need something new and different if you're going to move forward.
So there you have kind of the case progression, and we kind of were much more long-winded than we intended to be, as usual, Brett. But hopefully this gives you an idea of the beginning to end of a case, and every case will, of course, have their own kind of flavor, and not everything we talked about will happen in every single case, but now you have an idea of what's happening in the cases that you may be following. So with that, Brett, do you have anything else you'd like to add before we sign off for today?
This was obviously an overview. If you guys have questions about specific aspects of this, we talked about grand jury, we talked about jury selection. A lot of these things we haven't really talked about. So if there's something about these that you're really fascinated by, let us know. We're always happy to address these in more detail in a future episode.
Absolutely. Well, Brett, it's always fun to talk law with you guys. Hope you guys enjoyed this. And, thank you so much for all of your support, for listening to Legal Briefs and the Prosecutors Podcast, and for reaching out with fantastic questions and ideas. You can always reach us at prosecutorspod@gmail.com. Follow us on Twitter at prosecutorspod. We're on Facebook. There's the Fan Run Gallery Facebook page. And we are on Instagram. I had to remember what other social media we had. And we love hearing from you guys. So until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. Okay, there's my volume. I'm recording. The boys, they strike again.
The boys. The boys. Oh,
That's okay. It's safe. Taylor Swift's microphone is safe.
that's all that matters.
So until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. And this is the Prosecutors Legal Briefs. I forgot what we were doing.
You always do.